we're now ready for the next case, which is 23-1673, Sloan versus Fisher. Again, typically we have 5 minutes for the appellant. If you want something different, let me know. And with that, you may proceed.
Thank you, Your Honor. I'd actually like to reserve about 3 minutes for a vote, if that's okay. May it please the court, good morning. My name is Paulo Lima. I'm here on behalf of the defendant below the appellant, Hannah Sinclair Sloan. We're here because the trial court granted the plaintiff's motion for a new trial based on improper closing arguments. I think the place to start with it, and probably the ending point, is really the very onerous standard that the plaintiff had to meet. As we set forth in detail in our brief, none of these comments was preserved properly for appellate review. One comment wasn't even objected to at all. The others, an objection was sustained. Trial court then, in a couple of cases, gave a curative instruction. No motion for mistrial was made. And so the plaintiff is in sort of a difficult situation to argue now that this amounted to fundamental error when trial counsel sitting at trial failed to object or certainly failed to move for mistrial. We briefed the Murphy standard in a lot of detail in our initial and reply brief, so I'm not going to go prong by prong, but I do want to focus the court on the harmfulness prong, which the language that I'd like to focus the court on is that the improper closing argument must be of such a nature that it reaches into the validity of the trial itself to the extent that the verdict reached could not have been obtained but for such comments. And the reason we know that that's not met here is if we look to the new trial order, the trial judge stated, and I'll quote, that the court has, here's a quote, strong concerns that it is likely the improper arguments may have tipped the scale in such a closely contested case. And so the harmfulness test is just not met here. With that, I'll proceed to the individual comments. Certainly, if there's any particular comment the court would like me to focus on, I'm happy to do so, but absent that, I'll sort of run through them all. The first comment is that the, quote, plaintiff is hoping maybe you will not follow the law and maybe put 5 to 10% fault on the defendant. As we've argued, with respect to each of these 4 challenged comments, they were firmly grounded in the trial evidence. And this one is no exception. Counsel based the comment on the specific evidence, making the argument that putting even 5 to 10% fault on the defendant here would be inconsistent with the law of negligence. And he specifically cited the fact that you have 3 eyewitnesses, or the defendant and 2 eyewitnesses, who all agreed exactly what happened, and that the defendant was, certainly the jury could find, the defendant was without fault. And counsel stated that if you follow the evidence, quote, the only thing you can do is to answer the question of negligence of no. And so it's not an improper comment at all under the case law. We've cited that if there is record.
Is it ever proper to argue to a jury that one party or the other is hoping they will not follow the law? Ever?
Your Honor, I wouldn't use those terms. And that's sort of the theme that we see developed in the briefing here. The plaintiff wants to follow on a specific term. And we've conceded, frankly, in the briefing that if you take the individual sound bites, each one of those comments can sound pretty bad, quite honestly. But as the case law instructs us to do, we have to look at whether or not the evidence supports the comment. And so while obviously sitting here, would we advise trial counsel to use those words? No.
Phrased differently, and I know Judge Roberson talked about one of the objections was sustained, but it could be rephrased. Phrased differently, perhaps trial counsel's point he was trying to emphasize may be permissible, but as he chose to phrase it in that particular setting, and I emphasize, as trial counsel chose to phrase it, you contend it was proper.
We do contend it was proper because, again, we contend that it was proper, and if not proper per se, it certainly didn't rise to the level of harmfulness required under Murphy. And that's the other thing to keep in mind throughout all of this. Even if the court does conclude, well, this comment here, it crossed the line into impropriety. Can the court say that but for that challenged comment, the verdict would not have been the same? In fact, the trial judge himself didn't say so if we look at his order. The second comment is the medical case versus legal case. Again, in this one, I believe there was no objection at all. As a matter of fact, plaintiff's counsel objected, but on a different ground, later withdrew the objection. And again, we have defense counsel making specific reference to the evidence that supports that. Here we're talking about, he's criticizing counsel's request for money for future neck surgery and future lower back surgery to the plaintiff's SI joint, sacroiliac joint. And yet the evidence that's cited and that he discusses in the actual argument itself is that she had a neck surgery and she had a wonderful result. If you look at at her own expert's medical record, it says that, quote, cervical symptoms have completely resolved since surgery. Plaintiff's own treating surgeon, his notes, no reference at all to the need for any potential future surgery. And finally, a defense expert also testified that there would be no need to revisit the neck surgery. Similarly, with respect to the sacroiliac joint, the plaintiff's own expert's medical note from December 2022, 2 months before trial, indicated that she hadn't complained about lower back pain in 6 months. So again, it very well founded in the evidence itself, rendering that comment not improper. The other comment, the quote, smoke and mirrors, and here again, it's a phrase that comes up in the case law a lot. It's not a phrase that defense counsel, frankly, should be uttering very often. And in isolation, it sounds improper. But again, here, very, very carefully set forth in the argument, just before the smoke and mirrors came out, was the justification for that, which is that plaintiffs were claiming $26,000 per year for the migraine medication Nurtec, but that was based on 16 pills per month. But yet when you look at the trial evidence, the testimony was that just 2 months before trial, her latest medical visits, she was only having about 3 migraines per month, and the frequency was decreasing. And so counsel's comment obviously was, well, this $26,000 a year is wildly inflated. Similarly, with respect to the other 3 prescription medications, which accounted for about $12,000 a year in the plaintiff's, in their future medical request, those 3 medications, one was a sleep aid, another was a cognitive aid, another was an anti-anxiety medication, and it came out that the plaintiff had been on those similar types of medications for all of her adult life. And in fact, the day of this accident, she was on her way to a medical appointment to renew those prescriptions or to see her primary care physician, who would either continue or discontinue or adjust those prescriptions as needed. So again, a very, very strong basis for making that argument. The other point that I would make with respect to the smoke and mirrors comment, as well as the legal case versus medical case, both of those comments go only to the amount of damages. They don't go to liability, and we've cited case law in our brief that says that if an improper comment during closing argument goes only to the damages element but does not affect the liability, then it's harmless error, to the extent that the jury did what it did here, which is decide that there was no liability. So finding that there was no negligence, the jury simply never reached the damages question. And so difficult to say that, but for the improper comment, the jury would have reached the verdict that it did. Other question, the other comment was very briefly, the comment about separating fair and reasonable compensation from just a desire to simply make somebody rich. The trial judge even agreed with the defense that it was not an improper comment, could be rephrased. And if you look at the case law, where the case law that's barring the mention of wealth is not in this context. It's where the plaintiff's lawyer is essentially saying, stick it to the big bad insurance company or the big bad corporation with lots of money, let's hit the deep pocket and award my impoverished client some money. That's clearly not the context here. It didn't happen. It wasn't improper. It certainly wasn't harmful either, and not to the extent that Murphy requires. The other issue, which we've addressed in the briefing, the plaintiff has made a tipsy coachman argument that the court could affirm for the alternative reason, which was rejected by the trial judge, is that the verdict was against the manifest weight of the evidence. We submit that the trial court did not abuse its discretion here. There was ample evidence for the jury to find as it did that Ms. Sloan was simply not negligent here. That she, and with that we cite the evidence that Ms. Sloan and both eyewitnesses testified that when Ms. Sloan pulled out, turned right onto A1A, the right lane was unoccupied for a significant distance, giving her plenty of time to turn safely into flow of traffic. And secondarily, that the plaintiff, the testimony from, again, 2 eyewitnesses, was that the plaintiff abruptly and suddenly switched lanes from the left lane into the right lane, essentially sideswiping into Ms. Sloan as she pulled out. And so there's plenty of evidence, as the trial judge found below, that a jury could look at that testimony and say, well, yeah, there's no negligence here on the part of the defendant. I know in the briefing the plaintiff has brought up that, well, you know, the plaintiff was not violating anyone's right of way. And that may or may not be true, depending on who you believe, but the fact is it's irrelevant here because the parties agreed prior to jury instructions that the jury would not be instructed on traffic statutes, traffic regulations. The agreement was that the jury would receive the standard negligence instruction in Florida that we all know so well, reasonable care under the circumstances, and that's exactly the instruction that the jury received. And we submit that the jury applied it faithfully and found that Ms. Sloan acted reasonably when she checked the lane of traffic, saw no one in the right lane, pulled out into it, not expecting that the plaintiff would shift into her lane and crash into her. And so we submit that the court should reject the tipsy coachman argument. Unless the court has any further questions, I would just ask that the court vacate the new trial order and remand with instructions that the trial judge enter final judgment for the defendant in accordance with the jury's verdict.
One quick question.
Certainly.
Focusing on language, probably or may have affected the verdict or so forth. In these situations, is the trial judge supposed to, in his or her order, basically say that I find these improper comments collectively did change the verdict, or I mean, what is the legal standard?
Well, under Murphy, the law is pretty clear. I'm sorry?
It said, Murphy said the verdict reached could not have been obtained but for such comments. So to me, that suggests something pretty strong. I had tried to determine that but for these comments, this verdict wouldn't have to know. It's like a virtual certainty.
Right, and we would agree with that, Your Honor. And based on the trial judge's own comments, again, we've said in our brief that he commented that, well, this Murphy standard is very difficult and the court is unsure how exactly it should be applying it. But under the plain language of Murphy, I would agree with Your Honor that the trial judge would have had to say, essentially, that it was a virtual certainty. And frankly, he found the opposite, that it was a closely contested case. He rejected the against the manifest weight of the evidence argument that was raised by the plaintiffs. And so I would find that those two findings are inconsistent.
Could we somehow go behind the judge's order and go, well, we know what the trial judge said, but the three of us get together and go, nah, we look at it, it definitely did, but for the argument. I mean, are we allowed to do that under the standard of review?
No, Your Honor. I don't think that this court is capable of doing that. Again, this is a 5-day jury trial. The jury heard from 12 witnesses, more than 1,900 pages of exhibits. The trial judge is in the best position to articulate what he or she saw. And in this case, again, he's articulated that this was a very, very close case and that the jury could have gone either way. Thank you.
All right, thank you very much.
Thank you, Court. My name is Brian Lee. I'm representing the appellee Valerie Fisher. I wanted to start comments about some of the things that were talked about right at the end. Number one is that this court has an abuse of discretion standard in looking at this case. And so that is different than what I think the appellant, I'm not sure if they still are saying that this is a de novo standard, meaning that the court can basically review it on its own, just like they would the trial judge. It's very clear, and I think this court has put forth in its own case, Health First, I believe, that the abuse of discretion standard applies. And so when we look at this order, we look at the trial judge, as the person that was in trial, was reviewing these comments, was seeing what was occurring with witnesses, with juries, with counsel. All that kind of gets rolled into the abuse of discretion standard. The second thing I wanted to mention is there was this but-for analysis I think that Judge Makar talked about. The trial judge and Judge Roberson in his order says, and this is on the last page of it, says when he's talking about this but-for analysis, says finding that all three arguments are improper and having sustained objections to 2 of the 3, one of which was not objected to at all, the court still has strong concerns that it is likely the improper arguments may have tipped the scale in such a closely contested case. Later on, the judge talks about the damaging the fairness of the trial of public interest part of the Murphy standard. And what the court says is that defendant's improper argument was a broadside denigration of plaintiff, her counsel, and her witnesses. Such conduct is routinely admonished by our courts. Accordingly, the court must conclude that the public cannot and would not condone a closed contested case possibly being decided by a combination of patently improper arguments. What the appellant has noted is that, well, there's the word possibly in there. That's not enough. I disagree, because Murphy taught...
May possibly. I mean, that's...
Could, right, Your Honor, but Murphy, in the cases that talk about this standard, acknowledge that when what they're asking, really what the Florida Supreme Court's asking trial courts to do, is think of, okay, if these comments, what impact did these comments have on the jury? And Murphy talks about, in cases from that, thinking this court, says that is something that does have a little bit of speculation to it. It talks about possibilities. It's a trial court sort of putting themselves in the mind of, do I find this was incurable, even though it wasn't objected to? Do I find that this was damaging to the fairness of the trial? Which in and of itself talks about how a jury would have took those comments. And so there's an element of that anyways within the Murphy standard. What Murphy does not task a trial court to be able to say, I am absolutely certain that this jury looked at this comment and ruled this way because of it. It doesn't call for that. What the trial judge did in this case, and you can see by the trial court's order, is he did a very thoughtful analysis of Murphy. And frankly, put the struggle, which I think all trial judges have when dealing with Murphy, but ultimately decided that the improper arguments were such a broadside denigration, patently improper, that in this closely contested liability case, tipped the scales. Improper.
So let me begin with a question that I think the answer is evident, but I want to make sure. You agree Murphy's the standard and structure of our analysis?
I do.
No dispute on that issue?
No.
So how can we analyze the harmfulness factor? And I understand Judge Roberson's order, and I read it, and I understand the footnote he wrote as it pertains to what trial judges are called upon to do, etc. The harmfulness requirement in Murphy, number one, it says that the extensiveness of the objectionable material can be a factor to consider. And once the trial judge, in my view, rightly sustained the objection, gave a curative, and admonished not to proceed further with that line of thought, trial counsel did not try to proceed further. He complied with the court's order as counsel must. Is that right?
That's right. In the individual comments,
the harmfulness contemplated in Murphy almost seems, and I don't want to use the term as a term of art, but it almost seems to be harmfulness even beyond harmful error. What we would normally use the phrase harmful error. It almost seems to be harmful plus. Is that a fair understanding of the term?
I would say that's fair, Judge, because there's an element of, obviously, as the court knows, is the law where even if it's an improper comment, right, and even if it was preserved and it was objected to and all that, courts look at comments to see whether it was harmless error, whether it was harmful error.
Right.
And so so when Murphy talks about, and I was trying to get to the part in my brief where Murphy does talk about harmful, let me see, I think I can find it fairly quickly. Right, so harmfulness in Murphy as well as the USA casualty insurance case, it says in that context, harmfulness turns on how the argument affected the validity of the trial proceedings.
Right.
Now, Judge Roberson, I think, kind of astutely looked at the second prong and the fourth prong and said they kind of say the same thing. Although it's different prongs, and he looked differently. But I think that...
But we're in the realm of fundamental error now.
Sure, absolutely.
So Murphy puts us in the realm of fundamental error, and so that's when phraseology reaches down into the trial itself, etc., becomes more familiar to us. I think what I'm trying to focus on, and to some degree struggling with, is I don't have any qualms that at least two of the statements were clearly improper, materially so. Both were given pure instruction, and Judge Roberson, I think, clearly at one point said no more on the smoke and mirror statement. I think what I'm I'm struggling with a little bit is I am trying to understand how those two comments, in the midst of 1,900 pages of exhibits, 12 witnesses, 5 days of trial, compliance by trial counsel, how those statements can reach that harmfulness standard contemplated in Murphy. Related to that, as you begin to answer the question, and I certainly want to give you time to do that, relatedly, I'm looking at, Judge Roberson, I think, also rightly rejected the manifest weight of the evidence argument. Given the logging truck, and anybody who's ever been on the State Road 200 in Nassau County knows all about those logging trucks. And when those logging trucks talk about they have 300 yards and I would have no problem, and I take my foot off the gas anytime somebody pulls in front of me, which is a virtual certainty on A1A, when those witnesses are beginning to speak about what they're observing and the distance and things of that sort, and the trial judge then says, no, there's evidence they could have relied on in reaching their verdict of no liability in rejection of the manifest weight of the evidence, that has to have a bearing on the but-for analysis in Murphy, does it not? That's where I'm starting to run into a wall a little bit.
Sure, and I think just to kind of back forward, those can't be mutually exclusive things. But you can be looking at liability and manifest weight of the evidence argument, but then also look at the comments themselves differently, meaning that the comments themselves, and I think this is what Judge Roberson found, both individually and cumulatively met the Murphy standard. So let me answer the first question. So the harmfulness standard, I do think that in any case, there are comments that are on the edge. There are comments that a defense counsel can make that maybe were just went over the line of improper, and if they would have said it that was one thing. But then there are comments where Florida case law is very clear, whether or not it's preserved or not, are just fundamentally improper, and they cause reversals. We have two of those comments in this case. We have the defense counsel just blatantly telling the jury that plaintiff hopes that you'll just disregard the law. You won't follow it. On liability. Talking about liability. That is a fundamentally improper argument. There is no case that I'm aware of, going back to your question, Judge, where any court in this state has said, well, because of the context of the trial, that was proper. I haven't found it. I don't think they've cited it to you. And so that in and of itself is something that you do not say. And I do believe that is a heightened error. When we then go to a comment about smoke and mirrors, or smoke and mirror, and directly related to a witness with the clear implication, really explicitly, that this witness is making up numbers. That's this whole smoke and mirror thing. There is not a case that I know of where a defense counsel, plaintiff counsel, whoever, used smoke and mirrors where the court said that's okay. That in the context of this case, those words are correct. And I think the reason for that is, on both of those comments, is because that is going outside the evidence entirely. That is attacking plaintiff's counsel, plaintiff's witnesses. They did the trifecta in this case. They attacked all of them and denigrated every single one. The one that was not objected to, which really wasn't talked about very much, but it was this whole medical versus legal argument. And that, well, a medical case is where a plaintiff treats and they want to get better, and that's the whole reason for doing it. A legal case is where the plaintiff's already better, but they're just doing it to raise get themselves more money. It wasn't objected to, I realize that, but the trial court found that was fundamental error also, and I believe the reason is because, again, it is denigrating, it's not talking about evidence. It's not saying, hey, the evidence shows, there's no evidence that shows that you need these medications or this surgery. They're saying that they made it up, period. And every single one of these comments, when you look at them individually, I believe, they meet Murphy. When you look at them cumulatively, there's no doubt they meet it. Because every single one of those comments was a building block of the defense theme of the case. That not only was the plaintiff making it up, plaintiff's counsel wants you to not do your duty, and of course giving evidence that was made up, and that even plaintiff's witness is making it up.
What do we make of Murphy's guidance that the granting of the new trial is not meant to be somehow a means of sanctioning a wayward attorney? And I say wayward because I think that's the phrase Murphy uses. I don't mean his commentary. What do we make of that admonition of the Florida Supreme Court?
Sure, I think that it is. I think that admonition is for situations, and this is frankly just me, my opinion, for those situations where the comments are not these sort of clear-cut line comments, and it may, frankly, be how the trial court does an order on it. If the trial court were to talk about how the defense counsel was just totally out of line and, these things, and just kind of get very personal, right, about the comments themselves. If this court looked at them, were not something that had been wholly condemned, it was something that maybe in some cases they've allowed. But I think the Florida Supreme Court was trying to get the trial judge to take away sort of, I guess, the emotion of what a defense counsel did or what a counsel did in front of the court, and look at it in the sense of what was the comment itself, not the overall demeanor and what was happening. And so it was not. I think in Murphy they talk about it's not to punish the defense counsel. It's not a punitive measure just for defense counsel. It's something that you have to go through those factors to be able to show that it's not just one judge saying this. It's that this under the law is harmful, incurable, and all of those things. I'm sorry, go ahead, Judge.
Let me ask you this. Judge Sal asked you how the denial of the motion for new trial based on manifest way of the evidence plays into it, and I'm not sure I heard an answer.
You did. I frankly forgot about that part of the question. I apologize for that.
Give me the opportunity.
I appreciate that, Judge Edwards. So the manifest way of the evidence argument, it was not so much, and sometimes you see this argument where the plaintiff says, we're not liable at all based upon the evidence, and you have to direct a verdict for us, the plaintiff, because the defendant was totally liable. That wasn't the situation that was here. What the situation was here was that, I think plaintiff counsel said, look, the jury could find Ms. Fisher negligent in some way. But it was against the manifest way of the evidence for the jury to find that the defendant had no negligence. And that was because of the evidence that was in trial. Certainly there was evidence of what Ms. Fisher was doing, right, beforehand. And if you believe that evidence, of course, you could put a comparative negligence on Ms. Fisher. But there was also evidence that was really undisputed that Ms. Sloan really violated the right-of-way. And she was at a stoplight, she turned, she said she didn't see anything. Every single witness said that Ms. Fisher was in the lane going forward through that, and that she had the right of way. And so our argument to the trial court, which trial court rejected, is that not that we believe the jury's verdict was against the manifest way of the evidence because the jury didn't put 100% liability on the defendant. It was that they put 0 liability, and the evidence in the case showed at least some liability should have been put on the defendant. So that's the argument that we made below. Trial court disagreed with it. I've cited cases that talk about that specific point as to it is against the manifest way of the evidence when there is undisputed negligence that is within the trial, and for then the jury to not put negligence in that part.
But isn't this one of the rare cases where it really does look like this was an automobile accident? Plaintiff moved to the right lane about the same time as defendant came out. I mean, this is not one where the plaintiff's going down the right lane forever or comes out right, swerves over and hits the defendant. But I mean, they both, I think the logger who was back away and actually had brakes on his truck, he said they both were trying to occupy the same place at the same time. I mean, you say it's so clear that Ms. Sloan was negligent.
Right.
I mean, at some point, if you're turning right and there's nobody there, you quit looking to your left because you got to look to your right where you're going. I mean, couldn't the jury have found that?
Well, and
In fact, didn't the jury perhaps?
the jury did find that there was no negligence. We feel that the evidence was not that the evidence that the jury had from all the witnesses was that Ms. Fisher was in her lane prior to the turn, to that turn. It wasn't like a situation where, Ms. Sloan was turning and then right then, she was in the lane. She had kind of come around the truck. That was the evidence. It was in the lane, and then there was a turn in front of her. I believe that the property damage and all the different types of testimony showed that. It showed that this wasn't a situation where she was even out. She kind of came out and she didn't even get into the intersection, or the lane of travel. And all the witnesses agreed to that. All the witnesses said that. And so that's why we believe that that's a separate part that the trial judge just committed error on. I don't think, frankly, the court needs to get there, though, because we have such clear under Florida law comments that multiple courts have found are fundamentally wrong. Multiple courts. And we have a trial judge that, and frankly, by the way, Your Honor, some of those cases involve Murphy. Courts doing the Murphy standard for it. And so when we have that, and we have a trial court that used his discretion to make those findings, went through the analysis like trial judges are supposed to do, this court gives deference to that. And I wanted to just, as I end up here, I wanted to just read what this court said in Health First versus Catalog. This court held that it reviewed such a ruling under the abuse of discretion standard, and this is a quote, because the trial judge is in the best position to determine the impact of improper argument on the jury. That was this court citing to Murphy. And so when this court looks at that order, the trial court wasn't in the best position to do that. This court cannot overturn the trial court's decision unless it finds that no reasonable judge would have made the same decision.
In the case you're now citing to us, did the trial judge find that but for the comments, the verdict would not have been reached?
I believe that the trial court said that I certainly believe and then that case the trial court said yes, he believed that it was harmful and that it I think it was violated the public's confidence in the trial. I believe that. I don't know, frankly, if the court said that used the but-for language, right? But I know in this case, Judge Roberson did. He cited specifically to that in his order. So for all those reasons, Your Honors, we ask that the court affirm the trial court's order. Thank you.
Thank you.
Well, again, I'd like to begin with Judge Edwards' point that you were making about how the accident happened. And the quote Your Honor was thinking of was from Mr. Brandon, the truck driver, who said, "It happened so fast. It was one car coming out. It was like they were both trying to get in the same spot." I also thought that's a really apt description of the accident. I think counsel suggested that it was more of a rear-end collision, that Ms. Sloan had actually pulled out all the way and violated the right-of-way. However, that's not what happened. In our brief at page 7, and we're citing to the trial transcript at page 455, it says that the plaintiff's car struck the driver's side of the defendant's car, shattering defendant's driver's side window and shearing off the rear view mirror, of defendant's car. And so it was a situation where essentially it was a side swipe, as the truck driver said. They were trying to get into the same spot. And so this was a situation where the jury was justified in finding that there simply was no negligence. It was, as Your Honor put it, a traffic accident. There was a lot of talk about how this was an attack on plaintiff's counsel, on the plaintiff herself. The comments about smoke and mirrors were firmly grounded in the evidence. There's no reference to plaintiff's counsel, there's no reference to the plaintiff. It's talking about Gil Spruance, who was their life care planner / damages expert, and the testimony about how his numbers were essentially grossly inflated. And again, counsel explained exactly, it wasn't, I agree that the comment may have been improper, said, hey, look, their damages numbers, that's all smoke and mirrors, and moved on without any explanation. But he specifically said, let me give you an example. The Nurtec, the migraine medication, the numbers are based on 16 pills a month. The evidence that came out from plaintiff's own medical records is that it's 3 pills a month. Okay, so this wasn't just some unfounded broadside attack.
But does it not matter how a lawyer chooses to present the argument? Do the words he chooses not matter? I mean, smoke and mirror has been rejected in prior case law because it implies an intent to deceive or mislead.
Your Honor, again, sitting here today, if we were advising them on how to word that closing argument, certainly we would advise to avoid that terminology. But to the extent that this case turns on magic words, I want to take us back to Murphy, because Murphy specifically says, look, this is a hard standard, and it has to be hard. And they come right out and say, we're not completely closing the door on unpreserved error. However, it's supposed to be very difficult, and there are magic words that do trigger an automatic reversal under Murphy. But those are the ones...
I'd like to ask you a quick question.
Certainly.
If there were a reversal in this case, and the opinion to be written, it could find one of the Murphy factors was not met, and that's sufficient to reverse. Is that correct in your view, or do we have to show something more than that?
No, Your Honor. Only one Murphy factor, and frankly the easiest one, as I think has come out in this argument, is the harmfulness, that it doesn't meet the harmfulness plus, because I would agree also that it's not just standard harmfulness. Harmful error. In fact, the Supreme Court makes very clear that it's harmful error plus. It has to be something egregious that goes far above and beyond. And getting back briefly to the magic words that warrant a new trial are appeals to racial, ethnic, or religious prejudices, and other similar things of that nature. In that case, then yes, absolutely, it's new trial, do not pass go, do not collect $200. And so those are the sort of magic words, and otherwise you get where we are here, where we have to analyze, okay, let's take a look at the totality of the argument. Was it supported by the evidence? And frankly, again, the other good point is can the trial judge say, or did the trial judge say, that but for these improper comments, the jury could not have reached that decision that it did? And here we just don't have that, because again, the judge perhaps unwittingly contradicted himself within his own order when he finds that, no, this is a close case. There's certainly plenty of evidence from which the jury could have accepted the defendant's position that this was just a traffic accident. Ms. Sloan was not negligent. She pulled out thinking that she had plenty of time. And, unfortunately, as things happen, the plaintiff suddenly swerved into her lane and there's a collision. And so applying Murphy to this very difficult case, I think that, unless the court has any questions, I'll sum up and say I'd ask that the court vacate the trial order and instruct the trial judge to reinstate the verdict in favor of the defendant.
All right, thank you very much.
Thank you.
Well argued by both sides. With that, we shall be in recess.
All right. Yes, sir, I got you.